Well, good afternoon. I am assuming that those that are still here are looking for the real estate roundtable as opposed to just lost or, waiting for some other session to start. But if you are here deliberately, thank you. I had maybe about 4 or 5 just topics just to go over, but more than happy to actually engage with you on questions or issues that you're finding yourselves or your members are freaking out about, and where's guidance and whatnot. The first thing I just wanted to note is that we are looking to formalize the FOLA real estate committee a little bit more with representatives from across the province. So if you have a recommendation on somebody from your association who might be interested in that, just send me an email and we'll investigate from there. On a similar matter, though, issues of resources. So things that people may say, well, hey, I wish that I had access to this, or I wish I had a tool that did that. Is that something that FOLA should be looking into, investigating or providing for its members? It could be something as simple as a land transfer tax calculator, but it could be more complicated than that. What resources might make the most sense? We encourage that, plugging and referencing things like the real estate lawyers working group fee schedule. This is something that was an offshoot that FOLA had started at one point. It gained a lot of momentum, and this fee schedule is still out there. It's really related to residential purchases, sales, and refinances, what is considered to be potentially a fair and reasonable fee for charging those. There's a lot of trepidation at the first instance because it doesn't sound like a fixed number. It's a percentage, a very low percentage, but a percentage of the transaction for the nature of the work. And so there's the website for finding it. It's a great tool, actually. There's a PDF that can be actually delivered to the client that says, this is the fee schedule. So, there you have it. There's a worksheet in there to help facilitate what the fee, the disbursement, the taxes could actually look like. So it's a working document. It's not anything that's prescribed. Your association should not mandate its use. There's anti-competitive issues associated with that, but it's there. And then the fee that just addresses your, complexity, risk, the nature of what you're doing. And that is a moving target because increasingly in real estate we are saddled with much more liability than potentially we actually should be carrying. Our clients' liability isn't our own. We need to manage that a little bit better. A couple of other points, not sure that that's actually relevant, is the use of trust accounts. So there are issues ongoing with the Law Society about the regulation of trust accounts, the use of trust accounts, and how those should be utilized. The example that we circulated the last plenary and still have some work to do on it is real estate lawyers who are doing transactions, particularly for separating spouses or something along those lines, and they get into this rut where they are acting on the sales side, but there's 2 different parties, so they might actually have separate representation. The lawyer's kind of stepping in to facilitate the transaction, and then the lawyer is saddled and holding on to these sale proceeds for an indefinite period, pending the resolution of the underlying issue, separation, oppression remedy, co-ownership explosion, whatever it happens to be. And so the risk is that, trying to prepare a pathway so that real estate lawyers can try and anticipate that either in an engagement letter at the outset or some other method of communication that says, by the way, if this transaction, I'm getting the joint consent from everybody here, you're separately represented, I'm not advising you on your separation issues. The net sale proceeds are not delivered in accordance with a joint direction or a court order. After a period of time, what am I supposed to do with these funds? I'm not going to sit on these funds for 4 years. And if that's the plan, either the lawyer says, not my cup of tea, and away we go, or there's another pathway for it. I know some lawyers that will charge a fee for holding that for a period of time, the fee commensurate with the cost of administering the trust account. The report, if it's after a period of time, you have to tell the law society, you know who it is, but I'm just still holding these funds. So there is a growing question about the use of a trust account for those types of purposes, how it relates to the legal services that you're providing, and trying to draw a nexus there. And if there's an opportunity to charge for that, as even a disincentive or an incentive to having the underlying issue resolved, then there's another option. So that is still something that is being considered. I get emails about that from time to time, and is that something that FOLA should be looking into or not? But that's probably a dialogue with the members, your members, and also the Law Society at some point once there's a workable suggestion. The other item, there's two other items that I wanted to try and address here. One is with respect to title insurers and the requirement as of October 1st that title insurers are subject to FINTRAC reporting obligations. There's a couple of nuances that are there. The FOLA has highlighted the issue in an update. It's kind of buried. There might be, if there's a need or a preference, to have more guidance from what this should look like. Ideally, if lawyers are consistent. I know that title insurers were panicking because of the volume of residential transactions, those lawyers that do high volume residential transactional work, and how the title insurer would actually feasibly obtain the information that would be necessary for reporting to FINTRAC. And that's where the solution from their perspective was to have the lawyers acting as their agents for the purposes of facilitating that information, validating ID. So inherently, there's probably a lot of overlap. So there might not be a lot of concern associated with it. However, again, somebody else's liability isn't our liability just because we're involved in a transaction. So the agency arrangement with the title insurers should really be limited, firstly, just to validating and verifying ID, and it should be limited to doing so in accordance with our professional obligations. So to the extent that the Law Society has said these are the ways that you can validate ID, those would be the ways that you would be able to do so and maintain your own professional obligations. The fact that a lot of these title insurers are saying you have to validate ID, our preference is that you use our software, and if you do that, then we're all great, we're all set here. The issue is that until such time as the Law Society says this software, as of this date, is approved for your validation of ID, you may be behind the gun on complying with the validation rules. So insofar that you're prepared to accept an agency with a title insurer, you should maintain that that agency is limited only to the validation and in a method that complies with your obligations. There's no reason for you to take on an extra risk when you didn't intend it to be. And I say that limit it because some title insurers have noted that the FINTRAC rules are more expansive than just client ID. They have to provide information like the purchase price, the seller, the buyer, the lender, the amount of the mortgage, title problems, title issues, red flags that might suggest that there's an issue. Those are the title insurer's reporting obligations, and your agency should not spoon feed those issues over for reporting purposes. So to maintain that integrity, your agency should just be limited to that. Some of the title insurers' agency agreements are embedded in their terms of use, so you can't really see them unless you open up the terms of use. How many people do that? Not too many. So just making sure that those are top of mind. I'm raising this so that ultimately the members, real estate practicing members in your associations can get familiar with some of these concerns and these issues. In the course of applying for the policy, you might provide the title insurer with some of the information that they will need for reporting purposes, and that's coincidental. However, you would always need to have your client's consent before you start delivering that information. So for example, if it was a private mortgage that was going to be used and there wasn't going to be an independent title policy for that for whatever reason, divulging the details of the private mortgage might be an issue. And to the extent that some of those reporting obligations can be ascertained by the title insurers post-closing, then that's what they should do. They can get an updated parcel register post-closing, say, hey, by the way, FinTrack, here are all the details. Seller, buyer, amount of the purchase price, the amount of all is publicly available on the public register. Thank you very much. So keeping that, and what we heard a little bit earlier from Teresa Donnelly about how seriously the federal and provincial governments are taking anti-money laundering issues, we have to be mindful that we are helpful, but we have a different regime. And the Federation of Law Societies has worked significantly over the last decade to try and preserve lawyers having a separate but related regulatory oversight on that. And the last item that I was going to bring forward was with respect to the moving of money and wires. This is a big issue because there's no real consistency between it. By way of a brief overview, Payments Canada outlines the details of the systems that are used for moving money, validating funds that are moving through these various systems. The banks need to establish protocols and consistent with the bylaws of Payments Canada. They do that in their own unique way, and this inconsistency is what throws everybody into panic in some cases. Most of the banking industry is under an automated clearing settlement system. So if you think you take a check, you deposit the check, that goes into this clearance system. That check amount that's shown up into your trust account is actually a credit. It's not an actual dollar. And so it could take days, weeks for those to clear the system and then translate into a dollar eventually. In that intervening time, those funds can actually be recalled or not credited over. And that's, at this point, largely where most of the funds in our banking system tends to follow. The secondary system is what used to be called the large value transfer system, now the LINKS system. That system utilizes an electronic funds transfer that is owned and operated by Payments Canada. That is an irrevocable funds transfer. It goes, it lands. What happens between the going and landing is usually a bit of a mystery, but it goes and it lands and it's irrevocable. It generates, in the course of using that system, a payment confirmation code, which we call the PCRN, the payment confirmation reference number. The PCRN number is about 16 digits, I think, that it demonstrates that that's the system that's being used. When we talk about using a wire, it's a colloquial word that doesn't really have a meaning in the system. So while you could potentially have an e-transfer or a wire transfer, it's the system behind it that we're trying to get confirmation of. Using the PCRN number actually demonstrates that you're using that irrevocable system. And in that system, the funds can't be retracted. So when we have this conundrum of lawyers that are saying, deposit the funds into my account because it happens really quickly, I get those funds right away, they're actually just getting a credit. but it happens really quickly. The wiring of the funds using the link system may actually take a little bit longer depending on the bank's internal processes for pushing that through. Some banks like to wait till after lunch. Sometimes they'll wait till after 5. Sometimes they'll do it when they get to it. That process creates a little bit of an issue, but the funds are on their way. So as long as we know that the funds have been moved that way and can be traced back to a PCRN number, we're really just waiting for the funds to land. So over the last year, there's been 2 new cases on time is of the essence. And both of them were decided on the basis that the funds didn't land. And therefore, the vendor was able to terminate the transaction on the basis that the funds didn't land. One was, I think, 15 minutes late, and the other one was, I think, 35 minutes late. So we're talking about a ridiculous amount of time in between. The issue behind that, though, is that the lawyers actually facilitated the movement of the funds. The bank just didn't post them. So who was responsible ultimately for the failure to close is obviously going to be a live question, but in the end, the transaction was allowed to terminate on the basis that time was of the essence. So part of this is, at the grassroots level, an opportunity to try and create a protocol of some sort that might advance the cause of lawyers trying to move through this system, where if potentially we are closing, we have sent the funds, the recipient of the funds can verify that the information that was put into the wire was correct. Yep, that's my trust account information. That's all good. And here's the PCRN number that was used, so it's going to be using the link system, so it's guaranteed irrevocable funds. That would allow to close. Now that might be closing an escrow, but it might actually enable that we'd say we are closed. We can close on this. Registrations might occur first thing in the morning, or if the funds take an extra day, then there might be an issue about an interest payment that might have to be made or paid. But the protocol in the course of doing this would preserve the integrity of the transaction itself. In other words, reducing the scope and the scope and the prospect of one of the parties claiming that you didn't close because I didn't receive the funds. Again, it's a banking problem, but we tend to wear that hat. And so to prevent that, we would have this protocol in place. Early stage, grassroots, lots of questions. But ultimately, if we can try and create a system where that might work, then the more attention it gets, the prospect might be to utilize it. Potentially, adding it into a DRA or adding it into a guidance document or something along those lines. But what we can't continue to have is, one, clients that are misinformed about how the process works, that all the lawyer does is pushes a button and that's the end of the thing, and if the button doesn't get pushed, then it's the lawyer's fault. Too many claims where the lawyer just gets dragged in because of the last one's holding the funds, or the last one's pushing the button, or the last ones people are talking about, and it's just really easy, and there's an insurance policy behind it. That nonsense has to slow down and stop. And just a better way to educate brokers, agents, clients, bankers about the process. We really should be stopping processes where people are buying and selling on the same day, especially if interest rates are coming down. What is the cost of a bridge financing these days? Like if you're really talking about 2 or 3 days between sale and closing, without the prospect of all of this times of the essence risk that's going to play out and actually collapse a transaction and blow up a chain. The cost of a bridge financing, so every time I see a prospect of that coming in, I say, whatever you do, go back to your broker and renegotiate the sale closing date or the purchase closing date, make a difference. We are not in 1985 anymore. You cannot really deal with a buy and a sell on the same day. And believe me, you're going to have a million other things you're going to think about. Where's my moving truck? Where's my this? How am I going to do that? you don't need to buy and sell on the same day. Spend the extra $500 or $700 for 2 extra days on a bridge financing, and you can probably make it work. So we need to reshape how these transactions are working or not working, and help educate the system on what we do and how we can make it better.
I mean, it's fine to local realtors and all that, but have you approached RICO about our position with regards to that, so that they can then talk to their realtors, or is it just, we do this on a brokerage by brokerage basis when it arises?
So there's nothing that I'm aware of that's a concerted advocacy event. I think we have to get there, and part of it is granular. OREA is a little bit more difficult to work with, so we have tried a couple of times to address things with OREA through the purchase and sale agreements, right, which are conveniently structured to close the deal, make sure the deal closes, make sure we get our commissions. That happens. That RICO is the regulator, there should be some movement there. Part of the thing that makes me a little bit, head scratch is that there are lawyers that teach the certification courses, and they're teaching brokers about you only need 2 weeks for a requisition period. You really don't need to worry about the fact that your closing is at 6 o'clock, but really you can't do anything after 5 o'clock. Why are these lawyers teaching bad practices to these brokers and these agents in the first instance? Because that's not curriculum, it's just what's being taught. So campaign-wise, I think there's some merit to it. It's just like nailing Jell-O to a wall, though. But I take your point that some of that advocacy should be done at that level as well. So those were the main thoughts. Welcome to hear yours on those topics or other topics that are increasingly relevant or, just upset. Yes.
On the working group's fee schedule, that link that you posted, is there an online calculator or form where you can type in the purchase price and have it spit out suggested?
Yeah, it actually should be on that link. So if you haven't gone to it, the link will open up to another page that has a PDF that can be shared. So this is what you can expect to see the fee to look like. This is, or how it's calculated. These are generally the legal services that you can expect to be included in that. If you're going to put 3 mortgages on, you can expect the fee to be a bit different. That type of here's the PDF, this is what I'm charging, this is, the working group says I should. There's another resource that is a little bit more insular about how or why you should, look at it, what are the benefits. And there is, I think, an Excel spreadsheet that was developed by a lawyer. I unfortunately forget his name, but he gets credit for it on the spreadsheet, where you can put in a purchase price on a sale or a purchase or a refinancing amount. It'll ask you a couple of questions, including, is this a first-time home buyer, and it will try to generate what the fee would be under the schedule, what the land transfer tax might be. I'm not sure if it has a Toronto version for the Toronto tax, and a couple of other points that would help with that.
That's helpful for clients on the phone. They want to know in that instant what the fee would be, like just punching in as opposed to doing manually.
Yeah, and it doesn't address most disbursements. So that's going to be the other groan moment about we are now effectively in an age where we can't estimate just generally what a disbursement is going to look like. We can know what a registration cost might be, but we can't say your practice might be I'm going to order a tax certificate every time. I'm going to do these 3 government searches every time. And I'm not going to just wait for title insurance to cover it. So my disbursement level might be a bit higher than my neighbor for it, depending on which potential document software provider you're using, some of whom are just outside the door. the disbursement number could be different as well. And I raise it because while it's helpful to give a fee, the Law Society has rules about what we're disclosing that fee to be. And if you slip up on it, you're basically, that's the fee that you're going to charge. Don't go back after the fact.
And my other question related to that is around the anti-competition laws that you mentioned, and how is it that dentists have been so effective, and their association has been so effective at pushing a fee schedule, and that they haven't been tripped up by the anti-competitive laws?
Well,
I'm just using dentists as an example.
yeah. Yeah, because people don't like lawyers, and they're really easy to pick on, and it's, they're usually, you shouldn't do that, yes, I know, okay, fine, and they just they'll follow the rules. Dentists, any kind of medical profession that has typically out there insurance coverage for their services, like, I honestly think that should be reviewed, because that's kind of a scam all the way through. From my own perspective, this is not a FOLA thing, but that their fee somehow manages to be very close to what the insurance coverage is going to be. And if you said to them, I don't have insurance, they'll work out a different fee. That's a bit weird. So on the anti-competitive side, like law associations have had issues in the past with, fee tariffs, both on the litigation side, the estate side, and the real estate side, especially going back in a few decades, and that was seen to be just anti-competitive in nature. There's a brand new regime or uptake under the Competition Act and the tribunal, stemming from the bread issue and the grocery issue. And so there's a whole new mandate associated with it. So a whole opportunity for that to be looked at from soup to nuts, not just picking on lawyers, but I completely agree.
It's a real race to the bottom up there. It's like it's increasing risk that we're carrying and increasing amounts of work. Increasing our fees accordingly.
It is, and there's vultures waiting. They're just waiting for lawyers to give up and say, maybe you shouldn't be doing residential. Maybe something else should be doing residential. Right. And just waiting for that to happen, because for years, have been forcing it, and it's been resisted, significantly. You still need a lawyer's opinion to get a title policy. You still need a lawyer to sign off on a transfer. You still refinances. And some commercial deals too. Yep. And how complacent can we get, right? So it's only one thing. It's only one element. It's only one deal. And if it's more complicated than it's worth, they're just waiting to say, well, we'll take care of it for you. That's all right. So I think we just need to be vigilant about it, and then collectively, are we really prepared to hold on to it? And if we are, as we probably should, why can't we charge an appropriate fee for doing the work that's required of it? The resources to staff it properly, to address the issues that arise. We're not making shoes. We're doing something a little bit more dangerous.
And yet, 6% commission on their 700. I always show the realtor's invoice first, and then when I show my fee, it looks very reasonable.
I think it's less than the HST.
Exactly.
Yeah, but that's been socialized, right? So in the course of a residential transaction, unless you have a relationship with the client that they're going to come and talk to you first. Oh, I'm thinking about selling my property, or I'm thinking about this. It's going to come to you, and the client's going to come to you with a preconceived set of notions of what's going to happen. Oh, well, I was told I shouldn't pay more than this for a lawyer. Did a lawyer tell you that? No, oh, the person that, and this was coming at a time when the market was such that you basically could just stand out in your front door and say, I'm offering my house for set, and by the time you finish the sentence, you have 5 offers waiting for you. How does that justify a 5 or 6% commission, right? But I don't go out there and start blasting the broker about how much their commission is, but it's socialized. They control the process. They control what the expectations are. Right? Do you have a lawyer? Yeah, I do. Well, ask them how much they charge, because I have 3 others that, are really good, and they just do that. Like, they control that. Oh, do you need a home inspector? I know the home inspector. I know that. They do not want the lawyer to have access to the matter until it's firm, because the lawyer's going to get you out of that deal. Well, if you're worried about that, then you're worried about something else. What are you hiding? What's going on? Right? That's the conversation. I'm not a big friend to brokers and agents. I don't get my referrals that way. But those are the types of conversations. And I say that to clients, and I say, you need somebody who's going to be watching out for your interests. I notice that your agent is also the agent for the buyer. Are you sure you got your price that you're asking for? Are you sure that it was sold in the right manner? Are you sure that you're not giving a representation that you shouldn't be giving? So there is this issue about socializing the process, socializing the structure. Going back to the other point, why are you buying and selling on the same day? Well, it was really convenient. It is until it isn't. If you're not going to be able to get into your house that day, have you come up with a solution? Well, why would that be? I can give you 15 possible scenarios, none of which would be my problem or fault, right? But I'm the last one holding it. It's very easy to say, oh, you didn't take care of me, right? But we just haven't socialized that process, and we need to do that. And I also fear that there's a number of firms or lawyers that are still out there that are doing so much volume, maybe not in this market yet, but they're doing so much volume that they're not having those interactions with their clients on a regular basis. So maybe staff is, maybe nobody is, until there's an issue, and then it's like, oh, I think it's time to have a lawyer look at the file.
Going back to the traffic requirement, it's still, like, I'm still confused about whether I should be an agent or I should not be an agent on the title insurance. So far, onwards, I have said no, and I've directed them to the clients, and the clients have, they directly have their identification and their questions answered, and I feel that I am okay with that. That delays the issuance of the policy, but they take their time, although the clients do their part on the same day, but still I think the process is not fast forwarding from their end to the back end, and that's taking time, so sometimes I think that should I be the agent, but then the agency agreement says we may need reporting from you. That scares me off. So,
And the method of the reporting, right? So the conversations I'm starting to have with the title insurers are, what do you need from me as your agent to validate the ID, right? And in some cases, there's issues with that. So what about an attestation that here's a copy of their ID with my attestation that I have verified the ID in accordance with my Law Society's requirements. End of story. The method is not necessarily disclosed. I personally meet with the clients. Like, I will meet face to face and I will validate and verify that way. It's easier. We're working through another way through the credit reporting method that will make it a little bit easier. There are some limitations. The client has to be Canadian. They have to have been set up in the system in some way for it to actually work. But overwhelmingly, we do legal services for Canadian citizens or residents, so that's, easier. So that process of saying how we're going to comply so that we're not providing our background, our details over for their reporting obligations. And I think part of that is also in a plan to socialize the process. Why do we think that it's tangible to require a real estate transaction to be done in 2 days? We're getting a refinancing in that's going to close in 3 days. I don't think we're there anymore. I don't think we can do that and fulfill all of these other obligations any longer. If you need a transaction, this is the time frame. This is how this is how long it's going to take for it to be done right, without me having to carry your liability. So that's a slow, long road, but yeah, I personally am not.
So far, are you accepting that agency agreement or
Not the way that it's drafted. So I'll have a conversation with them and saying, I'm prepared to be the agent, but I'll do it this way. I've had some success with that. I'll verify it on my own. I'll provide you with a copy. Okay. Let's go with that. So I'm just looking at the time. I think we're largely done in terms of time, but I love these types of conversations. So anytime, my email is somewhere, you'll be able to find me, have those conversations. And if you are looking at or talking to your members, particularly the ones that are engaged in real property and they might be interested in participating on the real estate committee, I'd appreciate their names and their interest, and we can go from there as well. Thanks for picking the very exciting roundtable.